Good afternoon, everybody, and thank you for attending this Bristol Law Society hosted webinar, Quantum Update, both in respect of personal injury and clinical negligence. My name is Hugh Ponting. I'm a council member at the Bristol Law Society and also a partner at Enviable Law. I would just like to flag that this is being recorded. Slides will be available to you afterwards, and you will be able to access the recording subsequently on YouTube. We do have both a Q&A and chat facility available for you to pose questions as we go along, which we'll pick up at the end. So without further ado, I'd like to introduce both of our speakers today, who we're lucky to have, both from St John's Chambers. First of all, Marcus Coates-Walker. Marcus has a practice specialising in Clin Neg, PI and inquest work, regularly instructed in respect of high-value cases, often involving complex issues of causation and quantum, along the lines of some of the issues that are going to come up today. He regularly represents clients in multi-track trials, joint settlement meetings and mediations, and is a trained mediator himself. Instructed by both claimants and defendants, and appreciates the need to continually monitor what is an ever-changing market. He has significant experience in Clin Neg, including orthopedics, oncology, obstetrics, gynecology, gastroenterology, and dental, and is currently acting as junior counsel in high-value catastrophic brain injury claims. Further, he's represented clients in a wide range of inquest matters, including high-profile hearings with media interest. We're also joined by James Marwick. James has a busy Clin Neg practice with significant trial experience, again acting for both claimants and defendants. He has particular specialism in liability issues relating to gynecological and obstetric care. His Clin Neg work complements his PI practice, where he's often instructed where there are dishonesty issues involved, as well as cases involving chronic pain or somatoform disorders. He's presently instructed as sole counsel in a number of cases worth over £1 million. That's my introduction. With that, gentlemen, I'll hand over to you. Thank you.
Thanks, Hugh. Well, good afternoon, everyone. I think we've got a running total of about 24 attendees at the moment, so ever increasing number as we start today's webinar. Welcome from James and I. Hugh, that's an introduction. It sounds like the marketing team at Chambers have been working hard to sort of produce some nice things to say about us, so very, very kind of you for the introduction.
I'm sure you recognised yourselves.
Some of those on the attendee list I know well, some of them I know less well. So for those of you who haven't met me, as he says, my name's Marcus. You'll get to see from James in a moment. Briefly, in terms of today's webinar, what we are aiming to do is cover some of the key themes that the courts have been grappling with in cases involving issues of quantum. So we've scoured the judgments from 2019, 2020, tried to find the ones that are both interesting and might be useful in terms of drawing practical advice from, and hopefully can give you some pointers from a practical perspective as to how they might help you in advising your clients, whether you act for claimants or defendants. As James has kindly moved on to the relevant slide, we're looking to cover these following themes. So firstly, James is going to give you a rundown of how the courts are dealing with loss of earnings, in particular Ogden 8 and Smith & Manchester and Blaemire awards. Then I'll deal with how they're grappling with fatal accident claims, in particular how they're approaching dependency claims. Then James will finish off by covering, probably quite briefly, because you've, I would imagine, had quite a lot of information on the case of Swift and Carpenter recently.
Very briefly.
A case on divisible, or whether a psychiatric injury is divisible or indivisible. Before I hand over to James, those of you who have the video on screen may well see that I've taken the plunge and put up the Christmas lights early this year. I can only say it pales in comparison to the Marwick household, which looks like something out of a Hello Magazine competition of who's trying to win the brightest lights on the streets of Trowbridge. What we're going to try and do is entertain you somewhat with the cases, hopefully make them practical, and therefore, without further ado, I'll hand over to James to cover loss of earnings.
Thanks for that, Marcus. It's nice to take a break from my duties as the local Clark Griswold and to talk about quantum cases. And again, that's unusual for me because I normally get rolled out to talk about fundamental dishonesty. So I'm going to deal with loss of earnings. Excuse me, I'm controlling the PowerPoint throughout. So you have to bear with me because I have to flick it up with my finger on screen. So forgive me leaning forward. Can you talk about a couple of cases over the last 12 months or so, and the interaction with Ogden 8, which was, of course, published over the summer and will have an impact in future cases, and the approach in particular to the often argued issue of disability and how that impacts any awards for loss of earnings in these cases. Now, I haven't been able to find in my researches any recent reported cases which have grappled with Ogden 8 and, for example, which look at the difference it might make in terms of whether an individual claimant is disabled within the meaning of the Disability Discrimination Act 1995 as opposed to the Equality Act 2010. But we're going to look at what the impact might be in due course. But I'm going to start, if I may, with Inglis and MOD. Lean forward again. Now, I really like this case for two reasons. The first one's an obvious one, it's a lawyer's point, which is it gives a very good exposition of the principles relating to the interaction of Ogden and Smith and Manchester award. So whether or not there should be a lump sum award or a multiple count multiplier award. It's one of those cases you can look at and think, oh, you know what, I can carve out my skeleton argument for my case from this. But secondly, I like it. I like it's probably the wrong word, but I wince because I can see exactly the advice which the defendant MOD has had in the case and what it must have thought the outcome could well be if it contested the matter at trial. And when you read the judgment, you can see their case unraveling as the judge bounces them on each issue after issue as he goes through his judgment. But the basic facts are these. Mr. Inglis, he joined the Royal Marines at 17 years old, and he was discharged at 32 years old. By that time, he had many years of being exposed to excess noise, not untypical for a military claim, rounds of ammunition, helicopters, aircraft, the usual. And the balance of evidence was he had mild hearing loss, and he'd been voluntarily discharged at 32 years old. And he'd gone on, he'd secured employment in the private sector in the maritime security industry. And he'd remained continuously employed at most times by the time of trial, which was sort of 7 years or so later. Now, liability had been carved up on an 80-20 basis. And again, you do military claims, not an unfamiliar split on liability. And the case primarily went to trial on quantum issues relating to loss of earnings. Now, and this is probably the first tell as to why the defendant took the stance it had done. When the claimant had left the Royal Marines, he'd had an annual income in his final year, £26,000 per annum. But when he moved on into the private sector, that immediately bounced up to £40,000. And so the defendant ran at trial a primary issue to say, you've only left the Marines because of hearing issues, not because of your hearing issues, your mild hearing loss, but because of the financial incentive offered by prospects in the private sector. And they also said, look, it's mild hearing loss. You've remained in gainful employment for years since your discharge. So this is a Smith and Manchester case. It's Ogden gives an unreal outcome because essentially you'd be awarded over £250,000 for loss of earnings when the reality is actually you should only be awarded a 2-year lump sum. And let's follow Billet and MOD. And Billet and MOD is, of course, the case, Court of Appeal 2015, I think it's Rupert Jackson, non-freezing cold injury, claimants held to be only just disabled under the Equality Act. At first instance, gets an Ogden Award with an adjusted multiplier. At appeal, court says actually no. In cases like this, the lines blur, and actually it's a large lump sum award, 2 years of salary, and they replace the award of about £100,000 at first instance with an award of £50,000. And in this case, that's what the MOD said. Look, we're on similar ground here. Let's have a billet award. And that's why I come back to. You can see why the defendant's taken its stance, because it thinks, you know what, we've got a decent shout at winning on the primary factual causation argument, that he would have left. He was going to leave anyway. So there's no loss of earnings flow from the hearing loss. He's in the same position he would have been. But secondly, they're looking at the fact that his salary's gone up by about 50%, and they have in mind, you know what, the judge in a case of a relatively modest disability is going to have in mind a lump sum award. So you can well see why the defendant's probably taken the stance it's had, but it all falls apart at trial. Claimants held to have left because of hearing losses. There's good evidence from his previous supervising officer, which explains away the absence of contemporaneous reference. He's found to be disabled within the meaning of the Equality Act 2010. It's accepted that his hearing loss has a substantial impact on a permanent basis on his day-to-day activities, and the claimant's medical legal evidence on the narrow live issues in terms of the medical issues is preferred. The judge tinkers with the multiplier. So he applies a Connor and Bradman approach. So he says, look, if you're non-disabled, the multiplier is 0.9. If you are disabled, it's 0.6. But it's unrealistic to think that you're going to spend 12 years out of the next 30 unemployed. So he adjusts it to 0.8. And that calculates as an earnings loss of 250,000. Plus a consequential pension loss of 350,000. Now, the question it gives rise to is whether or not such an approach would be followed under Ogden 8. Now, Ogden 8 changes the approach to disability back to the Disability Discrimination Act 1995. And the Disability Discrimination Act 1995, as one of my later slides picks up, contains a more stringent test. It's widely recognised, because whereas the Equality Act gives a very sort of broad discretion to look at what the impact might be day to day, the Disability Discrimination Act requires one to look at its impact in particular on the following categories: mobility, manual dexterity, physical coordination, continence, ability to lift, carry, or otherwise move everyday objects, speech, hearing, or eyesight, memory, perception of risk or physical danger. And I think that probably gives us the answer in this case, which is that, well, actually, as it impacts hearing, there might well be a similar answer under the Disability Discrimination Act 1995 as there would be under the Equality Act 2010. Now, contrast that with, going back in my slides, billet, because in billet it was cold sensitization, and it's difficult to bring that into one of the factors in the Disability Discrimination Act note. So it might well be that billet wouldn't be disabled under the Disability Discrimination Act, but it's hard to see how Mr. Inglass, the position would change whether or not under the Disability Discrimination Act or the Equality Act. So I take a step back and think, well, what might have been the key factor where actually you've got someone who is in gainful employment, he's earning well, it has a relatively modest impact, even if it crosses that significant threshold, as to why there was an Ogden Award rather than the Smith and Manchester Award. And I think the answer is probably this. Once the judge had found that the career trajectory was changed by the hearing loss, so he discharged at 32, and his evidence was he would have worked later, the court has taken on board and said, look, this isn't just someone who remains in similar employment, the paradigm Smith and Manchester circumstances, but whose career generally has been impacted. And I think that's probably why we get the answer we do in that case. But it's an example of the court rejecting the billet approach and the making of a Smith and Manchester award. I think there would be the same outcome under Ogden 8, and I think it's a really useful case in terms of its overall exposition of the law on loss of earnings and the assessment of other heads of loss, such as loss of congenial employment. So I sort of commend a read of it. Other cases which are relevant in these circumstances. XX in Whittington Hospital NHS Trust. Look, it's not a recent case. Now, a lot of you will have seen that tag and say, it's the Supreme Court surrogate case, which goes up to the Supreme Court on the recoverability of those fees. This is actually, in terms of what I've cited in the notes, the first instance decision by Sir Robert Nelson, and the claimant who suffered some bladder and bowel injuries as a result of clinical negligence is disabled, but in fact she's been promoted since the accident. And Sir Robert Nelson at first instance says an Ogden award of £257,000, which would have been the correlation, gives an unreal outcome. And so had said, actually, you get an award of 4 times loss of earnings, so £25,000 per annum times 4, £100,000. And Sir Robert Nelson thought that that did justice to the case. It didn't go up on appeal on that point, but it gives us the full spectrum here. So if you've got someone who's really in classic Smith and Manchester territory, although there's an impact, the court may well follow billets. If you've got someone who's further up the spectrum, in terms of the level of disability, you might well get a full Ogden. But in between, the case law's really blurred the lines and given quite a wide discretion for the courts to either apply a Connor and Bradman type adjustment or a very large Smith and Manchester. Cited a couple of other cases, Kennedy where Ogden 7s followed, Murphy and MOD where billets followed. They're both worth a read. Obviously, each case, as is often the way, turns on its own facts, but they're well worth a read, those cases. The next case of interest, and I'm very immediately conscious that there's a typical barrister, I've sort of overrunning my timeline, but I'll do my best to be brief for this Irani case. Now, this is a case again from last year. Claimant suffered serious orthopaedic injuries in an RTC. He's on a visa working in the UK at the time, and he doesn't ever go back to work, and ultimately he loses his job under cover of a redundancy exercise. And at trial, he runs a case that actually he was really made redundant because of the fact of his injuries, and therefore it's a consequence of the accident. That what follows from that is that he doesn't have sufficient continuity of employment to obtain indefinite leave to remain in the UK. So his employment prospects in the UK are put in jeopardy, and he'll have to find gainful employment somewhere else, most likely in his birth country of India. He's a degree level candidate who, as I said, had been in solid employment up until the time of the accident. Now, the trial judge had said, the future evidence of what will now happen is too uncertain. And he'd awarded a lump sum award under blaming principles of £150,000 and a Smith and Manchester award of £30,000 for a disadvantage on the open labour market. And that was on the basis that there was very limited evidence put forward by the claimant as to what his residual earning capacity might be. There was some snapshots of some evidence from Indian websites as to what his earnings might be. There's some evidence from a friend as to what earnings could be in India, but there was no formal expert evidence. And the defendant had taken the point at trial in its counter schedule, in fact, that look, there's no expert evidence and the evidence is too unsure. And the judge followed that approach. He said, this is a paradigm case where there's no proper basis for determining the residual earnings figure, and there's no real alternative but to order a lump sum. And of course, in these cases where there's manifest evidence that there is a loss of earnings, but there's insufficient evidence to support a multiplier multiplicand award, the court can still make a large lump sum award. And the test is of no real alternative. And the decision awards a helpful previous case in 2012 on that point. Case goes up to the Court of Appeal on 2 grounds. The first is this: Claimant says actually the evidential threshold was crossed. There was ample evidence to make a finding as to what his earnings will now be, and therefore to apply a multiplier, multiplicand point. There's a cross appeal from the defendant on the basis that the judge was not clear enough in finding that the operative cause of redundancy was the injuries rather than simply a contributing factor, and therefore that but-for causation wasn't met. Court of Appeal upholds the trial judge. Court of Appeal says this is a classic, no real alternative basis. And I really see it, I mean, whether or not you look at it as a no proper basis approach or simply a burden of proof points, because uncertainty can also be code for not satisfying the burden of proof of likely earnings as a consequence of the accident. In terms of the redundancy point, they said that the judge went far enough, and effectively he found it was an operative cause. Now, that's a point that doesn't come up very often, a sham redundancy. But again, if you have that particular issue, it's worth a read on that point. In terms of the evidence of Indian earnings, look, the situation would probably have been remedied by a short form employment report from someone who is an expert in the Indian employment market. But that's very easy for me to say, sat here. I haven't had to instruct such an expert lately. And ultimately what the court had from the claimant was quite meagre evidence. So it's unsurprising, but it reinforces the jurisdiction to make such a lump sum award. And it's at the other end of the spectrum to the Inglis case. But where we're ultimately left with is Billet and MOD continuing to blur the lines, I say, between lump sums and Ogden calculations in those cases of only just disabled. And very finally from me on this issue, and the impact of Ogden 8, which I've had to touch upon as I've gone through to look at the cases I've talked about. Now, Ogden 8 requires the claimant to fulfill the three criteria I've just listed on screen there. I've identified the Disability Discrimination Act definition. It's going to be worth looking at the guidance notes to the Disability Discrimination Act, because that gives the checkpoints of the nature of the impact which the disability must have day to day in order to satisfy the court for an Ogden 8 calculation, that list of mobility, manual dexterity and the like. So it comes back to it's an acute list of criteria. It's not the diffusive approach under the Equality Act. And one very final point on there, in terms of the impact of Ogden 8, the guidelines to the new Ogden 8, they warn against adjustments where a lack of perceived disability. And what obviously that's a shot across the barrier's bound is, it must be the Connor and Bradman tinkering. And so if you have a claimant who is disabled, the editors of Ogden 8, they're saying, actually, you need to steer clear of tinkering with the multiplier for the purpose of the Ogden calculation. But I suspect that will continue because of what the Court of Appeal said in Billet. And Billet's the cause of why in most county schedules you see, even if you are disabled, we argue for a Billet award. So it'll be interesting to see how it turns out from here. That's my sort of first part of this. I think Marcus is going to talk a little bit now about some recent fatal accident cases.
Thanks, James. Just briefly before we move on to fatal claims, in terms of loss of earnings, are we able to draw a sort of a practical tip? If I put myself in the shoes of a claimant's representative drafting a schedule or a defendant's representative drafting a counter schedule, do those cases help us decide, or is there a practical tip arising from those deciding on how the court is likely to approach running an Ogden 8 or Smith? i.e., if I'm a claimant's solicitor or barrister, what's your practical tip in terms of, do I run an Ogden 8 claim, do I run a Smith claim, or am I in the remit of a blamer? And equally for a defendant's barrister, what's your one tip for someone in those positions?
I'm going to give 2 tips. The first tip is we're going to have to review any cases where there's been, in those ones which we suspect are more borderline, to make sure the expert will support that someone's disabled within the meaning of the Disability Discrimination Act and not simply the Equality Act. The second practical point is you've effectively got a hierarchy of 4 different types of lump sum awards now. You've got the full Ogden calculation unadjusted. You've got thereunder a tinkered Connor and Bradman, where the multiplier has been adjusted in order to reflect a perceived lack of true disability, if I can put it like that. Thirdly, you've got the XX and Whittington, a lump sum of up to about 4 times Smith and Manchester for those cases where even an adjusted Connor and Bradman award appears to give an inflated loss. And then at the very bottom, you've got your classic 6 months to 2 years Smith and Manchester. So I think the question is to make an early assessment of where you think it might fall on that hierarchy. I mean, a true Ogden case is typically obvious, but there's litigation risk to both sides now on those cases where the lines are blurred. Yeah. And I think it points us towards pleading potentially those alternatives in a schedule or counter schedule.
Yeah, and that's whether you're a claimant or a defendant, you need to have that sort of tiered system in mind.
Yeah, precisely.
Great. Well, thanks for that. Yeah, my job to try and cover the relevant cases that the court has dealt with in the world of the Fatal Accidents Act. So in short, 3 cases, you can see them up there on screen at the moment, dealing with dependency claims in slightly different contexts. So hopefully gives you an insight into how the court will treat different types of dependency calculations, which when you're either pleading a schedule or counter schedule may well provide you with some benefit. So the first case is that of AB and KL. We'll deal with the facts and the key issues first. Put shortly, the deceased in this case is GH. The claimant was his eldest son, who was an adult son by the time of the trial. GH died in a road traffic accident, liability admitted by the defendant KL, so no issue on that front. Claim brought by AB, GH's adult son, and also claimant brought the claim on behalf of his 2 15-year-old twin brothers. So there were 3 dependents in this claim for the purposes of the dependency claim. There were a number of issues, but the 2 key issues that are worthy of interest are, firstly, how much, if anything at all, GH would have helped his sons to buy a first home. Would he have given them some cash towards it? And secondly, how much would GH have contributed, if anything at all, to the cost of future weddings that they may or may not have had? Claimant argued that would have given the same amount to each of his sons in respect of a contribution to the first house that they would have bought and to get them on the property ladder, and also to the cost of any future wedding. Sums claimed, comment to them in due course, but 15 grand each in respect of contribution to first house and 12.5 grand each for the cost of contribution to the cost of a future wedding. Now, the key points here that the court were at pains to say before they went in to assess whether there was a valid claim here or not was 3 points, really. The first was they said they were going to look at GH's character and his relationship with his sons. Second, they said that they're going to look at his financial position in terms of whether he could actually afford to give any cash over to his sons. And then secondly, they were going to look at how GH actually behaved towards, how he would have behaved towards GH, how he would have behaved towards his sons had he not died. So looking in that 3-point way, the court said, look, GH, on the basis of the evidence we've heard from his ex-wife, so mother of the sons, and his son AB, was that he was found to be a loving and generous father who took an active interest in the lives of his 3 sons, in a nutshell. To give you a flavour of that evidence, so you can compare it to future cases that you might want to run or defend claims on this point. In terms of AB, who was 22 years old at the date of trial, AB lived with his mother, but with his stepfather, because they'd separated, mother and GH had separated pre-trial. The evidence was that he'd seen his father 2 or 3 times a month before going to uni. Whilst he was at university, he'd seen him during the holidays, and they'd undertaken activities together, such as fishing, cooking together, going to the pub. And the evidence was that they'd gone on holiday skiing together, and that Dad had provided him with financial support whilst at university. That was AB. In terms of the twins, to give you some context behind the relationship between Dad and twins, he was noted to have provided child support, albeit they predominantly lived with Mum. He had them to stay every other weekend and for 4 weeks over the summer holidays. And it was summarised in this way: he did the usual dad stuff with them. So activities, day trips, going to the cinema and holidays, etc. And broadly speaking, it was found that GH spent significant sums on his kids. So good relationship, loving and generous father to all 3 sons. In terms of his financial position, he was self-employed, but broadly speaking, he was noted to have average profits of about 80,000 a year. And even taking into account his own living expenses, it was still found that he'd be left with a significant amount of funds to be able to spend on his kids. So then we come on to the second bullet point on this slide. The court said, well, look, that's the factual exercise done. What about the counterfactual exercise? So how would GH have behaved towards his sons had he not died? Court said, look, bluntly speaking, this is a totally hypothetical exercise. No one can know exactly how he would have acted or how generous he would have been. There is total uncertainty with both of the claims being made. Court said, look, in terms of contribution to a first property, you only have to look at some of the questions. Will his kids buy a home, or will they rent for the rest of their life? We're in sort of generation, this country tends to be, first-time buyers tend to be in generation rent, as it's known. Will we continue? Who knows? But the question was posed, will they continue to rent or will they purchase a property? Would Dad have wanted to help them at all? If so, how much? And if he had wanted to help them, would it have been a gift or would it have been a loan? And if it was a loan, on what terms? So total uncertainty with regards to that claim. Court went on to say, in terms of contribution to the weddings, there was even more uncertainty. AB, being the adult son, by the time of trial was living with a long-term girlfriend who'd been with for over 11 years. They'd actually purchased a house by the date of trial, which the court said, look, these factors probably point towards marriage, but nothing's certain. The twins, however, were only 15 years old at the date of trial, I think 12 years old at the date of Dad's death. So the court said it's impossible to say whether they'll marry or not. And even if they do, will they, what will the cost of the wedding be? That'll depend on the nature and size of the wedding, the venue, the number of guests. Don't know the financial position of the parents of their other half and whether they'll contribute. It was noted, albeit perhaps less of a social norm in today's world, that these are sons, and so if it was a traditional religious ceremony where parents of the bride feel they're obligated to contribute, would they pay for the wedding so that GH in this case wouldn't need to? And even if he did, would the contribution be in the context of funds, or would it be a wedding gift? So court said inherent uncertainty with all of this. In terms of the approach they took, they said that the loss should be assessed by the chance of the event happening. There's no groundbreaking news there. They said, look, boiling it down to 2 questions, 2 points. If the prospects of an event occurring are so uncertain, which the defendant argued in this case, that they can be regarded as fanciful, no definition of what that means, then no damages should be awarded at all. But if they are not fanciful, the chances of that particular event happening, damages may be awarded in an amount which reflects the chance of that event occurring, applying a percentage reduction to reflect the hypothetical nature of the claim. So in this case, £15,000 claimed for each property contribution to each first property purchase for each son. The court said 15 grand's too much, we're going to award £9,000, so they awarded 60% of the claim as it stood. Contribution to the wedding, and they did that for all of the sons, so a consistent basis across the three of them, because they found dad probably would have been consistent with all of them. They said in terms of the wedding contribution, AB's chances, adult son's chances of having a wedding or getting married are greater than the twins' chances. In other words, the uncertainty in relation to the twins was greater than in relation to AB, because he was closer to that potential event. There was more evidence pointing towards it. And so if we flick onto the next slide and see the awards there, you can see what the court did in terms of the twins was said, look, we'll award 7,500, which was about 60% of the claim that AB made for the contribution to a future wedding. But the court said, look, we think there's too much uncertainty in relation to the twins, so we're going to reduce that and award each twin half of that amount, which is ultimately about 30% of what was claimed. So if we look at the practical points from this case, what does it tell us? Well, it reinforces that the proper approach in these types of cases is to look at the chance of something happening. And if you get over the chance of it being fanciful, and in this case, taking the largest stretch, which would be claiming that a 15-year-old child at the date of trial is likely to go on and have a wedding that his dad is going to contribute to, that was deemed not to be fanciful, so damages in principle were recoverable. What you need to do in these types of cases is carefully analyse the relationship between the deceased and the dependent, find as many examples of generosity or contribution or intended contribution in the future as is possible, whilst recognising that it's a hypothetical exercise, and then take a realistic stance as to what the percentage reduction should be to reflect the hypothetical nature of that exercise, bearing in mind that the closer to the event of happening that you are, so for instance AB being further down the line in his relationship and age, the more likely that, say, a wedding is going to happen. But the better the evidence, the lower the discount that is going to be applied. So that's the case of AB. We'll move on to the case of Ricks, case number 2. Here, Mr. Ricks, both this case and the next case actually, the deceased died of mesothelioma contracted from asbestos exposure whilst working for the defendant. Again, liability admitted, and after leaving his employment with the defendant, Mr. Ricks went on to be self-employed and built up a successful business. He and his wife in that business held 40% of the shares each, so 80% in total, and his two sons held the remaining 20%, so 10% each. Importantly, and I'll come back to why this is important in a moment, his wife didn't work for the business, so she had a 40% stake, but she didn't work for it. You can see the figures there pre-death. Both Mr. Ricks and Mrs. Ricks took salaries and dividends, and after his death, Mrs. Ricks inherited his shares, so she, post-death, had the 80% stake in the business. Sons maintained their 20% stake, 10% each, but they took over the day-to-day running. Mrs. Ricks didn't get involved in running the business after his death either. So move on to the next slide. Just that context is important. At no point pre or post-death did Mrs. Ricks get involved in the day-to-day running of the business or the running of the business at all. So the court claimant argued financial dependency should be calculated by on two potential bases. Fundamentally, they said there was a financial dependency, and it should be calculated either by reference to what they titled basis 1, which was the wife's share, by reference to the wife's share of the annual income that she and Mr. Ricks would have received from the business but for his death. So what's her share? What would she get? That's the amount of dependency. Alternatively, they said, look, if you can't work it on that way, Judge, we should calculate it by reference to the annual value of Mr. Ricks's services to the business, which we'd calculate by reference to the cost of employing a replacement for him. So they said, look, you're not bound by either of these two, but one of them would be an appropriate way forward to value this financial dependency. By contrast, the defendant said, actually, as a matter of principle, there's no financial dependency claim here, as the business itself had gone on to thrive following Mr. Ricks's death. So it had done better than when he was at the helm. They also said that when you actually boil it down, the wife's interest was essentially a capital or income producing asset, which negated the claim for financial dependency. So they argued as a matter of principle that she wasn't entitled to make a claim for financial dependency. That's a really helpful judgment on the authorities governing the calculation of dependency, the approach that the courts might take. And the court went through those authorities and helpfully set out some key principles, which I list here. The first three are pretty obvious, but worth bearing in mind. First, the question whether there's been a loss of financial dependency, and if so, how much, is a question of fact. So the court needs to delve into the evidence and look at the case on its own merits. Secondly, now this is really key in this case, the courts will take a realistic and common sense approach to these questions. They go on a number of occasions in the judgments, say they'll look at the practical reality of the setup. Now, when they look at the practical reality, the courts went on to say, look, we're not interested in the corporate, financial or tax structures that a particular family arrangement has in a family-run business. We're looking at what in practice happens. Even if, for example, Mrs. Ricks has a 40% stake in the business, does she actually do any work to benefit the business? If not, we'll factor that into account. Thirdly, they said there's no hard and fast or prescriptive approach to the determination or quantification of loss of financial dependency. The point to take from those three, before I come onto this slide, is the practical reality point. We'll come back to why that's important in this case in a moment. But the next slide that we were just on a moment ago, it is also key in this case. So the court said, looking at the authorities here, and they've gone through a number, probably don't have time to go through them. So we've distilled the practical point for you here, is that they said there is a difference between an income producing asset, such as rental property or an investment, where the money it produces, the profit and income it produces, doesn't really depend on the deceased or what they did. There's a difference between that, which wouldn't lead to a financial dependency claim, and a business which its income benefits from the labour, work and skill of the deceased, where they said if it's a case of that, then there is a financial dependency claim as a matter of fact, because if you remove that person from the equation who's inputting their labour, work and skill into a business, you are essentially saying Mrs. Ricks, in this case, has lost her main breadwinner in terms of the income. Mr. Ricks has been removed from the equation. That business depends on his skill. So therefore, there is a dependency claim there. Whereas if it was just an investment sat in a bank producing income from interest, for example, or on the stocks and shares market, it would have no relevance to, or Mr. Ricks would have no relevance to how well it performs. And so there would be no financial dependency resulting from that. So in terms of the next points that the court came from, so so far we've got important to look at the practical reality, important to look at the difference between a capital or an income producing asset and whether it's what the court determined to be a work and skill case where the business's income depends on the deceased's particular work and skill and input. They then wrapped up by saying, look, and there's the case of Williams and Welsh Health Ambulance Service, which is the authority for this point, which they relied upon. They said the question whether a dependent has suffered a loss of financial dependency for the purposes of the Act is fixed and determined at the date of death. And they say it follows in a work and skill case, so such as this, the existence of a right to claim loss of dependency and the value of the loss is not assessed by reference to how well the business has been doing since the deceased's death. That's irrelevant. It's fixed at the date of death. And they said further, a dependent can't, by their own conduct, affect the value of the dependency after the time of death. And so it results potentially in the practical reality of, even if a business is thriving post-death and doing better than ever, then you might get a situation where you still have a significant recoverable financial dependency claim, even though on the face of it, this is the defendant's argument, there is no pure financial loss because the business is doing better than ever. And the reason that the court said that was because they said you need to think about it like this. If there was no financial dependency in these circumstances, then it would lead to, or potentially result in, a perverse incentive to fail. And by that I mean that, well, the damages recovered if the business fails would be greater than if the business succeeds. And so the people at the helm of the business post-death may well be incentivized to make sure it failed to increase the size of their claim, or perhaps not work hard enough to make sure it succeeds. So they said because of that, there are policy reasons why Williams is right, and they went on to make a decision in the claimant's favour, and really can be distilled down to these 4 points. They said, as a matter of fact, the wife had a financial dependency arising from Mr. Ricks's death, for the reasons we've been through. They said, in terms of looking at how to quantify that claim, they chose the claimant's basis 1, which, to remind you, is the reference to the earnings that Mrs. Ricks would have continued to receive from the work done by her husband in the family company if he'd survived, rather than valuing the cost of his replacement. They said that no discount should be made for the fact that the company has thrived since Mr. Ricks has died, because it's fixed, the dependency is fixed at the date of death, and that the wife continued to receive an income from the business. And importantly in this case, and this comes right back to that point I stressed at the beginning, that Mrs. Ricks had no involvement in the running of the business. They said that her income should be included within the financial dependency, i.e. it should be not discounted from the calculations, because it shouldn't be treated as her income. It should properly be regarded as part of Mr. Ricks's income, because the practical reality of the situation is that it was only produced entirely as a result of Mr. Ricks's work and nothing to do with Mrs. Ricks. So on the face of it, you might have done your calculation and offset Mrs. Ricks's income from it. The court said, no, that's an inappropriate approach here. It should be discounted for those purposes, which ultimately led to a greater financial dependency claim. The final point before we move on to the next case is that what the court said in terms of choosing between the claimant's 2 bases, 1 or 2, those 2 approaches to valuing the claim, they said, look, in different cases, those 2 options may well be reasonable. You've got to look at the particular case in front of you. In this case, basis 1 was more appropriate, because primarily it was quite easy to distinguish between the income generating capital assets that Mr. and Mrs. Ricks held and the benefit that he produced from, or the income from the business that he was no longer able to work for. It was quite easy to separate the income from those 2, the 2 different types of income. So the one that would and wouldn't lead to financial dependency claim. They said in some cases it's going to be quite difficult to separate out something where you might have commercial property that you receive rent from, that rent comes through the same business, for example, as the business producing the income from which Mr. Ricks in this case was heading up. So they said where it's difficult to separate between those two different income streams, basis 2 as put forward by the claimant might be the more appropriate basis for valuation. And so you might want to look in those circumstances at the cost of how much it would cost to replace Mr. Ricks. So that's the case of Ricks. The final case, which we can probably deal with a little bit more quickly, is the case of Witham. So this is the third case that the courts have really grappled with in terms of dependency claims in the last year or so. The facts are fairly straightforward and similar-ish to Mr. Ricks's case in terms of Mr. Witham died from mesothelioma, again caused by asbestos exposure whilst working for the defendants. However, the dependency claim in this case was quite different. Mr. and Mrs. Witham didn't have children of their own, but had fostered 2 sibling children who were both on the autistic spectrum, aged 9 and 13 at the date of trial, and required quite considerable amounts of care. And so on that basis, Mr. Witham decided he'd give up his job and become the main carer for the kids, and Mrs. Witham would resume her nursing career. That's a decision they made and was in place at the time pre-death. After Mr. Witham's death, Mrs. Witham had no real option but to replace him as the carer and gave up her work. The main issue, therefore, that came before the court was, could Mrs. Witham recover for damages as a dependent on Mr. Witham, dependent on him remaining at home to provide those services in terms of childcare and domestic activities? Does that sound in financial dependency claims? Do they have a valid and recoverable claim for damages? Court held here, if we just move the slide up slightly, court held here that the dependency, so claimant argued, probably easier just to very quickly summarise each party's arguments. Claimant argued, look, there's a loss here sustained on the basis that Mrs. Witham, dependent on Mrs. Witham staying at home looking after the kids and providing care services. Defendant argued, no, that kind of claim is just dressed up as a dependency claim on behalf of Mrs. Witham, when actually it is truly a dependency claim on behalf of the foster children who, pursuant to the Fatal Accidents Act, don't qualify as dependents. So what the defendant argued was the claimant was trying to circumvent the statute, which didn't allow a claim on behalf of the foster children, whether fairly or unfairly. They said it doesn't matter, not allowed to be dependents. And so what the claimant is trying to do here is just dress up that claim as a claim for dependency on behalf of Mrs. Witham, and that's not allowed. Court dispatched with that argument pretty easily and says, no, the dependency was actually Mrs. Witham's rather than that of the children, and therefore we'll assess it on that basis. They said, look, in reality, she's lost her full-time career. Loss of Mr. Witham as the carer has decreased the family's finances as a whole. And then the key part of the claim was to decide on what basis should that claim be valued. The claimant said there's 2 potential ways of valuing this, and I imagine many of you have come across this argument in a lot of your dependency claims. The claimant says, look, you can either value this on the basis of Mrs. Witham's lost earnings, or you can value this on the basis of the replacement care. I think they put forward Mrs. Witham's lost earnings as the correct valuation basis because it increased the size of the claim. But the defendants didn't really engage with that argument. They just maintained that as a matter of principle, it wasn't recoverable because there was no financial dependency here. But if they had to concede that point, then really they'd say it should be the cost of replacement care. And ultimately, that's what the court held, was that even if Mrs. Witham rightly had a dependency here on Mr. Witham's services or lost services, they said it wasn't appropriate. I think they followed the case of Canara in this decision, and they said that it wasn't appropriate to value it on the basis of lost earnings, because they lost the lost earnings and lost pension and the pension loss, because they fall outside the ambit of Section 3 of the Act. And they said that in these circumstances, replacement care was the appropriate measure of loss. So if you've got a situation where the claimant in the case is claiming for, or their partner has died, who'd taken a decision to give up the job, be a main carer at home for foster children or any other dependent in need, I suppose, then the correct approach is that the dependency is the claimant's in terms of the partner, and the correct measure of loss is the replacement care, or the cost of commercial replacement care discounted for it being gratuitously provided. So in terms of practical tips from that one, just bear that in mind. I don't think you're going to make it as a defendant particularly far, arguing that the claimants are trying to circumnavigate the restrictions in the legislation against foster children, as they tried in this case. But on the whole, those three cases are quite a nice, broad range of context to show how the courts are dealing with dependency claims and the particular issues that can pop up when trying to argue them as a matter of principle or the basis of the calculation. So I'll probably hand back over to James at this point to probably touch upon the two remaining cases just quickly in terms of Smith and Manchester and the case of Leach.
Yes, so thanks for that, Marcus. Typical counsel, we're both panicking that we're probably going to be about 12 minutes each, and there it is, we're at 1:58 like that. Swift and Carpenter, not a widely reported case. You probably haven't heard of it before. No, you will have done obviously that the Key Court of Appeal case on accommodation claims, judgment out last month. Look, we don't have time to go into it in any event. You've probably heard lots about it already. I don't know if Marcus knows any better than I do from his role at PIBA, but I know the Court of Appeals refused permission to appeal. I don't know if there's been a potential renewed appeal to Supreme Court. My Google of typing Supreme Court Swift and Carpenter into the well-known search engine couldn't give me a conclusive answer. I don't know if you know, Marcus, any more than that.
Not as things stand, no.
No, fine. Look, it's unsurprising. The court found that Roberts and Johnson didn't give fair compensation. It was always realistic that the claimant would prevail. I suspect the insurer's main role was to try to minimise the outcome. We have a formula now, and there's various spreadsheets available for it. It's not a universal straitjacket. The point I'd probably make is it's not an answer to all your accommodation cases. So you might find yourself tearing your hair out trying to think, what am I missing here? But actually, it's certainly not apt to work with cases of shorter life expectancy. It gives issues where there might be changes in the accommodation claimant would have lived in but for the accident. And I'm expecting further High Court and or Court of Appeal consideration of those more difficult cases. So that's all I'm going to say about Swift and Carpenter. I'm grateful for the lack of time. Finally, I'm not going to say anything more than this. Leach and North East Ambulance Services NHS Foundation Trust, High Court decision is on a Judge Friedman, sitting in the District Registry in Newcastle. It's a 31-minute delay in arrival of an ambulance, leading to, well, materially contributing to PTSD. Defendant ran two arguments at trial, said it can't be a material contribution case, it must be but-for causation. That was rejected. The defendant also ran a second argument to say actually there should be an apportionment, because the reality is that most of the PTSD might be attributable to other causes, not to the 31-minute delay in the arrival of an ambulance. It was held that psychiatric injury was an indivisible injury and therefore there could be no apportionment. It's an issue which does come up from time to time, so it's worth a read if you have a case to do with psychiatric injury where there might be an argument as to divisibility or material contribution. Also some quite serious criticisms of experts in that case, so it's worth a read. We're over our time limit. I'm going to stop myself there, and I can just see a bit of Q&A's come in, Marcus, and have you seen that?
Yeah, so we have, thank you both. one question currently, which is, do the majority of clients in a personal injury stroke medical injury have digital access to their own records? And actually, I see there was another one as well about cash rather than card. So if we deal with that latter one first, do the majority of clients in a personal injury stroke medical injury claim have digital access to their records? I don't know.
As far as I'm concerned, no is the answer to that question. I think I've certainly heard murmurings in the news that there's going to be some attempts to try and make access or access easier for individuals to get hold of their own records, and perhaps I've heard suggestions that an app is going to be available and some software. But as far as I'm concerned, unless someone wants to put me right, and I'm quite happy to be put right, it's still a bit of an effort required to get those records on behalf of claimants. And in terms of whether they are digital or not, I think it depends on a trust by trust basis. They should be, but I suspect there's a lot of claimants representatives out there who have found themselves in situations where the records don't exist in a digital form, and therefore there has to be a hard copy deep dive, I think is the technical term that I've come across before. So I'm not going to pretend to be a tech wizard, but in my view, I don't think no.
It's certainly the direction of travel.
Yeah, the definite direction of travel. Certainly not quite there yet. Most businesses encouraging people to use card rather than cash. Is it easier for solicitors to assess someone else's finances, loss of earnings? It will be. HMRC will certainly be happy with the switch to cards rather than cash. It's an ongoing issue in claims, especially if someone's not been declaring their earnings or has been working in the grey market or the black market. So yes, and with tax going digital, I think that will ultimately be the answer to that as well. So certainly my experience is, even in my time at the bar, there's less issues than there were 10 years ago with people not declaring their earnings or otherwise dealing in cash and card. And obviously that's in terms of a loss of earnings perspective, but in terms of purchasing, whether it's medical treatment, medication or the like, there's far more likely to be an audit trail. Somebody can normally go online and find a receipt now, rather than having to say, look, it's my honest evidence, Your Honour, but I spent sort of £45 at Wilco on that pain analgesia. So hopefully life is getting easier.
How cynical we are, eh? Well, we don't have any further questions. We've slightly run over, but I'm very grateful to the majority because they've hung on. Thank you, Marcus. Thank you, James. Very informative. And can I just remind everyone that slides will be available shortly after this webinar. Do please as well have a look regularly at the Bristol Law Society website just to see what's going on. And also, if you could sign up to our monthly newsletter, I'm sure you'll find that beneficial as well. So until the next time, thank you very much.
Thanks, Hugh. I did signed up just as a stop press. The Court of Appeals just handed judgment down in the case of Hughes in West Hertfordshire, clinical negligence case, which has had quite a checkered judicial history. Worth a read, everyone. I won't say any more.
There we are. It's bedtime reading sorted out. Thank you both.